All right.
Hearing in the appeal, Manchester City Council against Pinnock.
Yes, may it please your lordships and my lady, in this case I appear together with my learned friend Mr. Stark for Mr. Pinnock, the appellant. My learned friends Mr. Arden, Queen's Counsel, and Mr. Manning appear for Manchester City Council. My learned friend Mr. Stillitz, Queen's Counsel, and Mr. Hooper appear for the first intervener, the Secretary of State. And my learned friend Mr. Luber, Queen's Counsel, appears for the Equality and Human Rights Commission. Lord, my lady, as you will know, this is our appeal from the judgment of the Court of Appeal, which in turn dismissed an appeal from the judgment of His Honour Judge Holman, delivered on the 22nd of December 2008. And Lord, I go straight to this point, that the judgment of the Court of Appeal proceeded on the express basis that two simple propositions flowed from the trio of House of Lords cases consisting of Karzai, Kay and Doherty, which were, of course, binding on the Court of Appeal, which now fall for reconsideration. But Lord, the propositions were set out, if I could take your lordships and my lady straight to it, in paragraphs 46 and 47 of the judgment of the Court of Appeal, which your lordship, the court will find at page 35 of the appendix. And at paragraph 46, Lord Justice Stanley Burnton said, "In my judgment, two simple propositions follow from these authorities." That's the three authorities I've just referred to. First, a landlord deciding to seek possession in a statutory context, such as the present, and the court making an order for possession, is acting so as to give effect to or enforce statutory provisions, and if those provisions are incompatible with convention rights, the landlord's decision and order of the county court is nonetheless lawful by virtue of section 6.2b of the Human Rights Act 1968. And the second proposition is that on a judicial review of the landlord's decision, the applicable grounds, with paragraph 47 over the page, the applicable grounds are those applicable on a non-convention domestic review, subject to the rationality test extended as stated by Lord Hope in Doherty and commented upon in the cases of Duran and Taylor. My Lord, we start from the proposition that those propositions, although inelegantly put, are in fact wrong, and I shall spend a substantial part of today trying to demonstrate that that is the case.
By wrong, do you mean that they misunderstood the earlier cases?
Well, by wrong, I mean, what I meant, it may be that they're not, in fact, to be derived from the earlier cases, but if they are correctly to be derived from the earlier cases, then they're wrong. As we shall see in due course, I think it's reasonably clear that quite a lot of the reasoning in Doherty was based on section 6.2b, and I shall submit that that reasoning was with respect wrong. And as I also understand it, and certainly the way the Court of Appeal in the other cases has understood Doherty, it continues to make a distinction between conventional judicial review grounds and breach of section 6.1 of the Human Rights Act. That's a distinction which, if it exists, I wish to attack. But That's where we've got to.
Mr. Down, you're quite a long way away, so I
Sorry,
wonder if you could put, no, that one's on, but why don't we try that one on as well?
Can I try both?
Very good, thank you
And
very much.
shout if you can't hear. Yeah. And my lord, if your lordships go to our printed case, we have set out in paragraph 7 onwards of our printed case an overview of the perspective we now advance on behalf of Mr. Pinnock. And we say in paragraph 7 that a basic and fundamental proposition advanced on behalf of Mr. Pinnock is that with the benefit of hindsight, it can now be seen that the law took a wrong turning with the decision of the majority in Karzai. That approach is irreconcilable with subsequent decisions of the European Court of Human Rights, which also led, in conjunction with the subsequent decisions in Cahill and Doherty, to a complex body of law which it is respectfully submitted is difficult to apply. That body of law includes at least 2 features which are, we submit, undesirable as a matter of basic principle. And then the 2 are a distinction between review of a public law decision on traditional, purely domestic grounds and the approach required by Section 6.1 of the Human Rights Act, where convention rights are engaged. And 2, a reliance, as explained in Doherty, on the defences available to public bodies by the 2 limbs of Section 6.2 of the Human Rights Act. My Lord, paragraph 9 of the case sets out our basic approach in a demoted tenancy case, which we say that if one can put aside for one moment the very considerable complications caused by the trio of House of Lords cases and by the procedural aspects of the post-Karzai line of Strasbourg cases, that's Connors and McCann and onwards, there is a relatively simple analysis available to Mr. Pinnock, which runs as follows. Firstly, the actions of a local authority either to demote a secure tenancy or to recover possession of a demoted tenancy are the actions of a public authority for the purposes of Section 6.1 of the Human Rights Act. Secondly, further, the actions of the review panel acting under Section 143F of the Act are also actions of a public authority for the purposes of Section 6.1. Thirdly, a decision to evict from a home, and accordingly the various decisions described above, engages Article 8 of the Convention, specifically and importantly for present purposes, a decision of the review panel engages Article 8. Fourthly, it follows that if the decision of the review panel is not a proportionate reaction to the legitimate aim it pursues, it's rendered unlawful by Section 6.1. Any domestic court with the jurisdiction to do so could and should so rule in just the same way as it would rule on the legality of a decision said to be flawed by a conventional domestic public law error. And fifthly, the defences for a public authority created by either limb of Section 6.2 are irrelevant for the purposes of this analysis. The statutory scheme is modern, and nothing in it compels the review panel to reach a decision which is disproportionate, just as nothing in it compels the review panel to commit any other public law error. And that will be, as we say in paragraph 10, the judgment of Lord Justice Stanley Burnton in the court below, paragraph 22, I needn't take your lordships to it, records a similar submission to that made above. His perspective on how in practice to apply the analysis on these facts differs sharply from that urged by the appellant, but as far as the basic analysis is concerned, he indicated at paragraph 26 that apart from authority, he would have been tempted to accept the analysis, and we will have to have submissions as to whether the decision of the review panel was in fact disproportionate. Well, my lady, at that point we have not mentioned Section 7, that is our basic analysis of the Human Rights Act provisions, but I need to throw into the matter of statutory construction Section 7(1)(a) of the Human Rights Act 1998, which clearly indicates that where a person claims that a public authority has acted unlawfully because of a breach of Section 6(1) of the Act, he can rely on that illegality in any proceedings brought by the relevant public authority, including the in-possession proceedings brought by a housing authority following a decision of a review panel under the demoted tenancy schemes, which is unlawful because the review panel breached Section 6(1), because the decision is disproportionate, then that illegality can be relied upon by Mr. Pinnock in the course of these possession proceedings. Now, my Lord, that's our analysis as it applies to a demoted tenancy, and in a sense, the analysis is easier in this case precisely because, as we say in the printed case, the demoted tenancy scheme envisages that the housing authority, to bring the tenancy to an end, will carry out a series of steps, each of which are the acts of a public authority, and each of which can therefore potentially be a breach of Section 6(1). It may be helpful if we spell out at an early stage how our analysis would work where the statutory scheme, where there is no specific statutory scheme in play, because the particular right of occupation can, as a matter of private property law, be determined unilaterally by the public authority. The tenancies in Connor, in Kay, and in Doherty are such examples. The tenancy in McCann is a variant because there the tenancy is brought to an end by the unilateral action of, sorry, not the unilateral action, that's the wrong description, by the action of Mrs. McCann at the instigation of the housing authority. But in all those cases, there is the tenancy is brought to an end without the operation of any statutory scheme. But in our submission, the analysis in such a circumstance is firstly the action of the public authority in terminating the right of occupation must, if it is to be lawful, not infringe any convention rights, and in particular not infringe the Article 8 right to respect for the home. Secondly, if that action is disproportionate, it will breach Section 6(1) of the Human Rights Act. Thirdly, we submit that this conclusion cannot be avoided by reliance on Section 6(2)(b) of the Human Rights Act 1998. Well, we'll come in more detail to this, of course, in due course, but I put down this marker. We gratefully adopt the analysis of the operation of Section 6(2)(b) put forward in Lord Mance's speech in Doherty. And once again, we say that Section 7 will permit the defendant to rely on the alleged breach of Section 6(1) in the possession proceedings brought in the county court. So we'll say something in due course about how common it may be for convention defences to arise, but the starting point for these submissions is that since Kazi was decided, a compelling line of Strasbourg case law has emerged which makes it clear that the analysis cannot be avoided, at least unless Section 6(2)(b), as explained in some speeches in Doherty, avoids the result. So, my Lord, that's back to the initial outline of our case. Lord, I proceed, if this is acceptable, to proceed by, first of all, taking your lordships and the court to the statutory scheme relating to demoted tenancies, and secondly, to the evolution of the line of cases in both Strasbourg and in the Lords that informs the basic argument in front of your lordships.
Could I ask you, before you go to the statutory scheme, to explain the use of the word modern in your proposition little 4? I mean, obviously it is a comparatively recent scheme, but is there something about modernity that we should bear in mind as we look at it?
We probably overplayed modernity in the written case. It's not just because it is modern that Section 62B can have no relevance. I don't know, having reflected on it, see, put it in that way. But we do say that it's a rather startling proposition, if it be anybody's proposition, that in a modern scheme, which confers on the review panel a judgment to be made about whether to bring the tenancy to an end, the outcome of those deliberations is somehow compelled by the statutory scheme to ignore proportionality. It's more as a question of surprise at the result than any actual reliance on modernity. It's completely excluding the operation of 62B. But your lordship will already have our basic point, which is that if one looks at the statutory scheme, the review panel has to decide whether or not to uphold the review of the decision to to end the demoted tenancy. Plainly, I think it's common ground by everybody that in making that decision, it has to act lawfully in conventional judicial review grounds. We see no reason, and we submit there is no reason, why in this scheme the review panel should not also act compatibly with Article 8, which means make a proportionate decision. There's only going to be arguments about what that involves, but they would plainly make a proportionate decision. So, my lord, my lady, can I then go to the statutory scheme for demoted tenancies? We've outlined basic provisions in paragraphs 3 to 6 of our printed case, and take the court to them as they exist. The basic regime starts with section 82 large A of the Housing Act 1985, which, as these things would have it, was not included in the original authorities bundle or in the appendix, kind of fell between two stools. But we have circulated to your lordships a thin volume which makes good that omission, and which includes section 82A. I can simply have to apologise for the fact that of all the provisions, it was the one that got missed out. And can I also say to the court that we know we owe additional copies to the legal associates and to the law reporter, and we haven't provided enough copies this morning. But section 82A is dealing with secure tenancies, and 82A1 says this section applies to a secure tenancy if the landlord is A, a local housing authority, B, a housing action trust, and then private registered provider of social housing, registered social landlord. 82A2, the landlord may apply to a county court for a demotion order. 82A3, a demotion order has the following effect. The secure tenancy is terminated with effect from the date specified in the order. B, if the tenant remains in occupation of the dwelling house after that date, a demoted tenancy is created with effect from that date. Then C deals with two automatic terms of the demoted tenancy, which deal with rent, either arrears or credits. And then 4, crucially, the court must not make a demoted order unless it is satisfied, A, that the tenant or person residing in or visiting the dwelling house has engaged or threatened to engage in conduct to which Section 153A or 153B of the Housing Act 1985 applies. That relates to antisocial behaviour or use of premises for unlawful purposes. And B, that it's reasonable to make the order. So pausing there, I of course fully accept that the tenancy is only converted from a secure tenancy to a demoted tenancy if a court properly so rules, and the court is obliged to consider whether it's reasonable to make that demotion order. I anticipate it's common ground that at that stage the court would have to bear in mind everything, but everything would include the convention rights of the tenant. It would have to be satisfied it was proportionate to make the demotion order.
And is that a different balancing exercise to the subsequent two exercises, or the same?
We say it's the same. One of the confusing aspects of the way in which the case law has developed is to what extent there is a difference between conventional judicial review, as explained in Doherty, and proportionality. But it's an important difference for this immediate case. I mean, the essence of a proportionality exercise is that the public authority or the court concerned identifies the legitimate aim which is being followed and then decides whether or not the making of the demotion order or the subsequent termination of the tenancy is a proportionate reaction to that legitimate aim. Now here, I fully accept that if one is looking at the matter in Article 8.2 terms, the legitimate aim will include in the enforcement of the rights of the landlord to recover possession. That will form part of the legitimate aim as part of the rights of others. It will also include potential beneficiaries of a redistribution of the housing stock, other potential tenants. But it will also include, and crucially in this scheme, the protection of the neighbouring occupiers. Indeed, one might have thought that with a demoted tenancy regime, that was the principal thing that the housing authority or the court ought to be thinking about. And when we come to the proportionality issue on the actual facts of this case, we do say that a very sharp proportionality issue arises, conceding as I do that it is a legitimate aim to protect the other inhabitants of the housing estate on which Mr. Pinnock lives. One has to ask, how does the termination of the tenancy achieve that when Mr. Pinnock's sons are adults, will frequent the area in any event, and where there is no mechanism that's been suggested that will prevent them, if they are going to cause trouble, continuing to cause trouble. There isn't a relationship between the ending of Mr. Pinnock's tenancy and the protection of the immediate neighbourhood. Plainly different with younger children or whatever, but if you've got adults who've grown up and essentially left home, then there is a real proportionality issue involved.
Isn't that a factual judgment? It seems to me, on the face of it, quite probable that adult children might frequent an area where their parent still lived, but not do so if he or she no longer lived there.
Well, I'm not disputing for a moment that you couldn't have a factual analysis which said this for 3 or 4 Pinnock children will no longer frequent the area if Mr. Pinnock is evicted. But that is never stated, and indeed we'll come to this much later when we come to the facts. Indeed, the sons, I keep on trying to avoid using the word children because they're not children at this stage, have their own girlfriends in the area, their own friends, and so on. So I agree it's a factual issue, but it's a factual issue which proportionality requires the court or the housing authority to grapple with. Well, we'll come back to the facts of the case in due course, but that's the answer I give.
Yes, just going back to my question.
Yes. Sorry.
Issue one is demotion. Should there be demotion?
Yes.
And is the test there, having regard to the conduct that's taking place, does this justify removing the tenant from his home?
Yes.
Provided only that there are grounds for thinking that this will continue, leading on to the next stage, i.e. is the discretionary element as to whether the behaviour has been so bad that it justifies taking somebody away from his home. Really a question that arises largely at the demotion stage, not at the termination stage.
Well, I understand your lordship's question. No. As the judgment in the court below, in the county court, of the recorder who made the demotion order indicates, there are two possible situations that can arise where there has been a course of antisocial behaviour and the court and the council wishes to apply to the court for a remedy in relation to that antisocial behaviour. It can apply simply to terminate the secure tenancy and recover possession on the same basis, on the same facts. And indeed, that's precisely what happened in this case. The Manchester applied for an outright possession order, or in the alternative, a demotion order. They got, in the event, simply a demotion order. The judge, the recorder, holding that although a demotion order was draconian, it was justified, but it will be too draconian to immediately order outright possession. So we say that one then goes on through the statutory scheme. When you come to terminate the demoted tenancy, true it is that you will do it against a background where the conduct has been sufficiently serious and the problem sufficiently serious to justify demotion. But you will still have to look at the factual position as it exists in order to decide whether or not it's appropriate to terminate the demoted tenancy.
So from human right terms, or applying the human right test, demotion has not been prejudicial at all.
No, I don't. No.
Is that right?
No, I don't accept that at all. One comes to apply proportionality on the basis that there has been already a serious course of conduct which has led to the tenancy being demoted, and that something much less serious will need to be demonstrated at the final stage. It's not that you forget the first stage completely, or indeed at all. It's a very, very important part of the background. But you still have to have some reason that makes it proportionate to finally end the demoted tenancy.
Is that because, in effect, when the terms are set out for the demoted tenancy, it's a kind of warning, really, that unless the behaviour is addressed during the relevant period, the ultimate step will be taken. So are you saying that you have to look again at the facts to see what has gone on in the interval?
Yes.
And see whether, looking at them afresh, there are proportionate grounds for taking that final step?
But completely accepting, I don't shy away from this, that it would be very much easier at that end stage to justify the termination, precisely because the tenant has been placed on probation. You may have seen from the facts of this case, given a pretty stark warning by the recorder that it was the very end of the line, and any more trouble might lead to a breach. It might lead to the termination of the tenancy.
Can you help me on this? As a matter of practice, do local authorities normally apply for a demotion order on its own, or is it almost always the double-barreled approach as happened in this case?
As a matter of common practice, I can't answer that. There may be others in the room who can. I mean, I know enough to know it's quite common to do both.
I think, in fact, on the facts of this case, originally the application was for demotion only, according to the agreed statement of facts. And it was then when the recorder handed down his draft judgment and the City Council asked for the matter to be reopened, and then paragraph 1.6 of the statement of facts it issued a possession summons as well in separate proceedings,
Yes,
and they were linked together.
I'm sure your lordship's right, and I apologise for having got that wrong here. So, I think that I don't know the answer to Lord Newberger's question about common practice. I anticipate that it is possible to do both in tandem, and that happens from time to time.
Would you say that both steps in the proceeding amount to an interference with the right to respect for the home?
Yeah.
In other words, the one that simply changes the legal status but does give a rather firm warning, and the one that actually takes away the home.
Yes,
Both
I would say they were
experiences.
both separate interferences with the right to respect. They both need to be justified under Article 8.2. The justification for the second step will, on the facts, be easier, precisely because the tenant has been given the warning and an independent court has found that the conduct which led to demotion actually existed. But that doesn't mean that proportionality has no role.
Is a right to a secure tenancy property also?
Well, the right to a tenancy is certainly property.
I mean, secure tenancy is different from a demoted tenancy. Anyway, maybe it's irrelevant.
Yeah, well, I think the actual answer is yes, because you will be ending one clutch of a mixture of contractual obligations, terms of the tenancy, both arising from the actual terms of the tenancy itself or the statute, and replacing that with another less valuable right because of the terms of the demoted tenancy. So that is substituting one property right for another property right. Whether anything turns on it, I suspect not, because we've never run an Article 1, Protocol 1 case. It's simply Article 8.
I mean, would you accept, Mr. Abel, that on making a demotion order, I mean, the County Court judge is saying, I regard it as proportionate that you be evicted if within the next 12 months you put a foot out of line?
Well, I'm certainly accepting and do accept that the judge, in making the demotion order, is saying it is proportionate to put you at risk of eviction without any statutory security if things go wrong. Cavill, you still need to demonstrate that something relevant has gone wrong, and that's in itself serious enough to justify eviction, given the starting point that you've been given the warning. Well, not just the warning, you've had your status reduced to that of a demoted tenant. Well, going back to the statutory scheme, we've got that all arose, I think, from 82A4B, reasonable to make the order. 82A5 I don't think 82A5 matters. It just simply continues the parties and so on as on the original secure tenant. 82A7 is relevant because that provides that if the landlord of the demoted tenancy serves on the tenant a statement of any other express terms of the secure tenancy which are to apply to the demoted tenancy, such terms are also terms of the demoted tenancy. So, as your lordships, my lady, will have seen, when it came to argument in front of the panel in the present case, and indeed in front of His Honour Judge Holman, terms had been served on Mr. Pinnock, which had effect pursuant to 82A7, in particular the terms that made it clear that he was to be responsible for the conduct of people residing with him or visiting him. If your lordships and my lady will then go to volume 2,
Bundle.
And to tab 10 is the first tab. We find a scheme relating to the ending of a tenancy once it has become a demoted tenancy. The court will go to section 143B. This is not, I'm afraid, it is about half a dozen pages in to tab 10. (143B1), a demoted tenancy becomes a secure tenancy at the end of the period of 1 year, the demotion period, starting with the date the demotion order takes effect, but this is subject to subsections 2 to 5. And then 2, a tenancy ceases to be a demoted tenancy if any of the following paragraphs applies, and then thus the landlord or tenant condition fails to be fulfilled, demotion order is quashed, tenant dies and no one's entitled to succeed to the tenancy. And 3, if at any time before the end of the demotion period, the landlord serves a notice of proceedings for possession of the dwelling house, subsection 4 applies. And then 4, the tenancy continues as a demoted tenancy until the end of the demotion period, or if later, until any of the following occurs. And then A, the notice of proceedings is withdrawn by the landlord. B, the proceedings are determined in favour of the tenant. C, the period of 6 months beginning with the date on which the notice is served ends and no proceedings for possession have been brought. And then 5 provides that a tenancy does not come to an end merely because it ceases to be a demoted tenancy. And then going on through the statute, the Lordships will go on to 143D, it's just over the page. Proceedings for possession, 143D1, the landlord may only bring a demoted tenancy to an end by obtaining A, an order of the court for possession of the dwelling house, and B, the execution of the order. And then 1A, in such a case, the tenancy ends when the order is executed. And then 2, this is an important provision for the purpose of the argument today, the court must make an order for possession unless it thinks that the procedure under sections 143E and 143F has not been followed. The Court of Appeal construed that provision as meaning that the only thing the county court was concerned with was whether the procedure actually described in 143E and F had been followed, in the sense that each of the relevant steps had been taken, and was not concerned about whether the following of the procedure consisted of lawful steps. We say that the natural reading of 143D2 is that the court must make an order for possession, is that it should read, the court must make an order for possession unless it thinks that the procedure under 143E and 143F has not been lawfully followed.
Has not been, sorry, I missed the final word, not been
Lawfully
lawfully,
followed.
thank you.
In other words, consistently with the whole of our case,
Yes.
the procedure under 143E and F involves a series of steps taken by a public authority. If the step involves a breach of Section 6, the procedure has not been lawfully followed, and on that basis that would excuse, we would say excuse the county court from making an order, we would say compel that it didn't make an order.
Could you help me a bit on subsection 3 of section 143D? And the print we have in volume 2, that's missed out. But the Court of Appeal, in their summary of the provisions, and I'm looking at at page, it's in paragraph 6 of the Court of Appeal's judgment. They quote subsection 3. Now, it may not matter too much, because it just says if the court makes such an order, the tenancy comes to an end on the date on which the tenant is to give up possession in pursuance of the order. Fairly obvious point. But what's happened to it? Why has it been taken out? And do we need to, should we assume that for our present purposes subsection 3 is relevant?
Some of your lordships will be familiar with the 2000, my lady will be familiar with the 2008 Act.
How could we ever forget?
Yes, indeed.
I see.
Mr. Luber will remember it too.
Yeah.
The law should be as set out by the Court of Appeal, because that's the law as it stood at the time of the relevant proceedings.
That's what I thought, yeah.
There is a change made by the 2008 Act, which is part and parcel of the situation in which reforms were made to deal with tolerated trespassers.
Yes.
And there are a whole series of transitional provisions, as the court, some members of the court know, which are slightly different in the case of demoted tenancies, and I hope to goodness we don't get into that.
Yes.
But that's why C's gone and been replaced by some other transitional provisions, as I apprehend.
But somewhere there will be a provision to the same effect. In other words, that
Yes.
the tenancy comes to an end on the date at which the tenant is to give up possession.
I hesitate slightly about answering that question, and maybe if I hope that your lordships and my lady won't be concerned with that, because
Well, sorry, it's dealt with by 1A. It
1A,
was
sure.
put in by the 2008 Act, wasn't it? 143D, 1A.
Oh, right, I follow, yes.
no, right. I'm sorry.
Yes,
I'm
in simple
very
form.
slow, and I apologise.
Yes, that's my fault. It's a simpler form.
Yes, I'm sorry. That's correct.
Yeah, right, thank you.
Yes. So I think I'm right in saying it's part of the 2008 reforms, but the answers are apparent on the face of the statute, as Lord Walker points out. And then 143E provides proceedings for possession of a dwelling house let under a demoted tenancy must not be brought unless the landlord has served on the tenant a notice of proceedings under this section.
Just a question. If a demoted tenancy survives the year, then it ceases to be one. Can the local authority make another application immediately, or is there a bar on that?
I think he can make another one. My immediate answer is that he can make another one immediately. Presumably it would have to be based on further factual allegations. Further allegations that would have to make out a case afresh that the antisocial behaviour requirement had been fulfilled. But I think it can do it again.
It can do it, but it's not.
Yeah.
Thank you.
143E1. Proceedings for possession of a dwelling house let under a demoted tenancy shall not be brought in unless the landlord served a notice, and then the notice must A. state that the court will be asked to make an order for possession of the dwelling house, B. set out the reasons for the landlord's decision to apply for the order, C. specify the date after which proceedings for the possession of the order may be begun, D. inform the tenant of his right to request a review of the landlord's decision and of the time within which the request must be made. And we're pausing there. When we come to the detailed facts, there is an issue which arises as to whether or not the review is confined to the reasons set out in the notice under 13E2B. The Court of Appeal held that it needn't be. We have a submission that it has to be. And then there's a limitation on the timing of the date under 143E2C, and then there's a requirement about what the notice must include, and then 143F, review of decision to take possession. before the end of a period of 14 days beginning with the date of service of a notice for possession of a dwelling house let under a demoted tenancy, the tenant may request the landlord to review its decision to seek an order for possession. 2. If a request is made in accordance with subsection 1, the landlord must review the decision. 3. The Secretary of State may by regulations make provisions to the procedure to be followed. And then 4 provides for the contents of those regulations, providing both for the seniority of the person who carries it out and as to the ability of the tenant to require an oral hearing. And then 5, the landlord must notify the tenant, A, of the decision on the review, B, of the reasons for the decision. And then there's a rather awkward provision about the timing of the review, 143F6. The review must be carried out and notice given under subsection 5 before the date specified in the notice of proceedings as the date after which proceedings for the possession of the dwelling house may be begun. Now, in fact, as was accepted by all parties in the court below, it's very difficult to always carry out the review within that time limit, and the Court of Appeal held that the time limit was directory and not mandatory, as a result that there was no... You can still carry out a review even if you missed the time limit specified in the notice of proceedings as the date after which the proceedings for possession may be begun. And then 143G the section applies if the landlord has begun proceedings for the possession of a dwelling house let under a demoted tenancy and A, the demotion period ends, or B, any of paragraphs A to C of 143B2 applies. I don't think we need to be concerned with that. And I don't think the remainder matter. Because it's dealing with the right to buy or change of landlord. So well, that's the basic statutory scheme. The regulations for review are to be found at tab 18 of the same bundle of the appendix.
Could I ask you, before you go on, I think there is a provision about the jurisdiction of the county court, isn't there?
It's
143N. It might be worth just glancing at that.
Your Lordship is entirely right. I should have gone for that. Yeah. About 4 pages on from 143G, your Lordships and my Lady will find 143 large N, which deals with jurisdiction of the county court. 143N1, the County Court has jurisdiction, A, to determine issues arising under this chapter, B, to entertain proceedings brought under this chapter, and C, to determine claims for whatever amount in connection with a demoted tenancy. And then 3, subsection 3 is important for some of the arguments in this case. For the purpose of subsection 2, it's immaterial that no relief other than a declaration is sought. And 4, if a person takes proceedings in the High Court, which by virtue of this section he could have taken the County Court, not entitled to recover any costs. And your Lordships and my Lady would have seen that His Honour Judge Holman relied on 143N1A to say that he had jurisdiction to decide the public law issues that arose in the possession proceedings that followed the review.
Does this confer jurisdiction? It simply gives jurisdiction in respect of whatever issues there are which could arise under previous sections.
Yes. I don't particularly rely on 143N1 as showing that the County Court has jurisdiction which it wouldn't otherwise have to determine the human rights issues that arise. I rely on the line of House of Lords authorities for that proposition. So I agree. I don't think that 143N1A would confer a jurisdiction on the County Court if on other principles
Or is this where section 7 comes in at all?
Yes, but not to the 143N1 way of putting it, but simply on the basis that, as Lord Bingham has explained in I think, both Kazi and Kay, section 7 enables the Human Rights Act defence to be taken in the county court possession proceedings.
Which tag is the Human Rights Act?
That is
Tab 11.
11. Yeah, thanks. So it's this bundle. Yeah.
it's tab 11. I'm grateful to know Mr. Luber.
So section 7(1)(b is it?
Yes, while we're here, of course we'll be looking at these in a moment, it's possibly sensible just to draw attention both to section 6(1), 6(2) and section 7. 6(1) I've been referring to repeatedly, but it's a simple fundamental provision that it's unlawful for a public authority to act in a way which is incompatible with a convention right. But then 6(2)(b), the wording may matter more, because 6(2) is split into two, as your Lordship and my Lady will know. Subsection 1 does not apply to an act if, and then A, as a result of one or more provisions of primary legislation, the authority could not have acted differently, or B, in the case of one or more provisions of or made under primary legislation which cannot be read or given effect to in a way which is compatible with the Convention rights, the authority was acting so as to give effect to or enforce those provisions. And in Doherty, I think it's fair to say there was a division of view as to what the concept of giving effect to or enforcing the provisions of legislation which cannot be given effect to in a way which is compatible with Convention rights. Come back to that in due course. And then section 7, person who claims that a public authority has acted or proposes to act in a way which is made unlawful by section 6(1) may bring proceedings against the authority under this act in the appropriate court or tribunal, or rely on the convention right or rights in any legal proceedings. The second bit that Lord Bingham in particular has explained makes it possible to rely on a convention defence in the county court. And we make that submission too. My Lord, finally on the statutory scheme, your Lordship should be aware of the Demoted Tenancies Review of Decisions regulations, which are at tab 18 of the same volume. Regulation 2 indicates that the persons who carry out the reviews shall not be involved in the decision. That's 2(1), and shall be senior to the person who took the original decision. Then Regulation 4 provides for a right to an oral hearing. Regulation 5 provides that the tenant can make written representations whether or not the review is to be made by way of an oral hearing. And then Regulation 6 provides that where the review is to be made by way of an oral hearing, the tenant shall have the right to be heard and to be accompanied or to be represented by another person, and that the tenant or his representative may call evidence and question other people who give evidence. Well, that I think is, unless I've missed something else, that is the statutory scheme for present purposes.
So how long before the year is up would a local authority have to set the ball in motion?
To get it done before
to get it done, or at least get the proceedings started, because starting the proceedings extends time, doesn't it, until the proceedings are disposed of. So What's the timescale?
Well, the timescales actually required by the regulations needn't be long at all, but in practical terms it will take some little time. I don't really wish to say more than that to carry out the review.
Is there a statutory time limit for telling the tenant that he's got to ask for a review? In other words, clearly there isn't a review unless a tenant asks for one. If the review is being done by oral, you've got to give 5 clear days' notice of the date of the review.
Yes, indeed. Go back to this annual legislation.
But I
143, I mean, told
Yeah.
by Mr. Luber very helpfully. The Lordship is the lady goes back to 143E.
Well,
1432D provides that the notice informs the tenant of his right to request a review of the landlord's decision and of the time within which the request must be made.
so that allows the local authority to choose how long to give him.
Oh, does it?
Or does it?
I wonder whether...
That's what I'm getting at.
Yes, I wondered whether 143F1 is setting a time limit. It seems to mention a period of 14 days beginning with the date of the service of the notice. So what the local authority,
Yes,
as I thought, were having to do was to say, by the way, you've got 14 days under the statute.
Well, the notice will state you have the 14 days that is provided for in 143F1.
So you've 14 days,
Yes.
and then the review can take place not less than 5 days after the request.
Yes.
So we're talking 3 weeks at least, aren't we?
Yes. So certainly talking 3 weeks, and I suspect that in practice it's longer than that.
Yes.
But is it something which, in fact, postpones the right to commence proceedings until after the review? So 143E, subsection 4, has a different postponement date.
Comes the date for proceeding.
Yes. I mean, could you, so to speak, if you were giving it the notice of proceedings rather late in the day, commence proceedings protectively, while at the same time informing the tenant of the right to request a review of the decision?
I thought the answer to that must be no.
I've been told from a variety of sources that all you need to do in order to maintain the right to take proceedings is serve the notice of proceedings under 143B.
Yes.
It's a combination of 3 and 4. I'm sorry to be slow about this. If
Yes.
at any time before the end of the demotion period, that's before the end of the year, the landlord serves a notice of proceedings for possession of the dwelling house, subsection 4 applies, and then 4 continues the demoted tenancy until the end of the demotion period, or if later, any of the following occurs. A, the notice of proceedings is withdrawn by the landlord.
And then you obviously have 6 months, so that that contemplates that the proceedings could be commenced long after the year.
Yes.
Yes.
Yes, provided you serve the 143B3 notice.
Am I right in thinking that the section 143E2 little c date is important when one looks at 143F6? In other words, the date specified in the notice is the date by which the review must have been carried out. Is that right? It does seem to say in subsection 6 of 143F that the review's got to be carried out by a date specified somewhere, and it looks as though it's the date in the notice that you look at. and the notice therefore has to allow sufficient time for the review. But what I can't at the moment see is how that date is selected, whether the local authority is tied by some other provision to allow so many weeks or whatever it is to allow the review to be carried out.
Yeah. There's a minimum, as Mr. Luber points out, under 143E3.
Yes. Ah, I see. So you take the notice to quit period, which would be, what, 28
that's
days?
only the minimum.
Yes.
Right. And that's,
yes.
as a matter of practice, it's fairly uneasily with 143F6, because the idea that you carry out the review within the notice to quit period is potentially problematic.
Yes.
And it's for that reason, if I'm getting this right, that the Court of Appeal said that the requirements of 143F6 were directory rather than mandatory, because otherwise the whole machinery collapses if you don't get the review in before the end of the notice to quit period.
Yes, thank you. Thank you.
That was that last wrinkle. I hope that is the third wrinkle.
Well, I'm sorry for setting that hair running, but it's all very
No, it's
confusing.
important.
It's quite important.
Quite important. Now, my lord, my lady, that's the first of my tasks. The second task is quite large task, is to take the court through the progression of both the domestic and the Strasbourg authorities. And we'll make it plain, as I have done already, that it is our submission that with the benefit of hindsight, it can be seen that the minority in both Kazi and Kay were correct. And what has happened since Kazi is that the starting point of Kazi has not been abandoned by the domestic courts, but instead has been modified. And the result in our submission is an overall body of law which is difficult to apply and contains, in our submission, the two problematic propositions, namely that Section 6.2b is in play, and secondly that there is some fundamental distinction between conventional judicial review, even as enlarged, and breach of Section 6. Well, therefore, the starting point has to be Kazi, which your lordships and the lady will find at volume 4 of the authority file, tab 41. Court is no doubt familiar with the basic facts. That the Kazi is very similar but not identical to McCann, in the sense that the undisputed domestic right of possession arose because Mrs. Kazi served a notice to quit to terminate the joint tenancy. And your lordships will see the facts shortly described in the top of the headnote on page 983 of the authority. I don't read that. But the finding of the court was twofold. First of all, that Mr. Kazi was occupying the house concerned as his home, despite the fact that he had no legal right to be there. That was the unanimous view of the Lords. It does not now arise. Secondly, the second finding was allowing the appeal, with Lord Bingham and Lord Steyn dissenting, but having regard to its object, Article 8 could not be relied on to defeat propriety or contractual rights to possession, that the domestic law gave the housing authority an unqualified right to immediate possession once service of the notice to quit had terminated joint tenancy, But since it had been clear from the tenancy at its outset that it could be so terminated, and since the premises, once recovered, will be available for letting to other persons in need of housing within the authority's area, there was no infringement of the defendant's right under Article 8, and accordingly no question arose for determination under Article 8.2. My Lord, that summarises the view of the majority, that in our submission, with the benefit of hindsight, as I say, this court should now follow the reasoning of the minority. My Lord, if you go to your Bingham speech, page 992, paragraph 14, Lord Bingham summarises a series of the existing Strasbourg case law as at the date of Kazi. Come back to those very shortly, one by one, in a moment. But he's doing so at this point in his speech in the context of deciding the first issue, was this his home? But they're all relevant also to the second issue that he had identified, was the right to respect for the home infringed. Lord Bingham identified the two issues at page 989, letter H. His conclusion, having cited those Strasbourg authorities and the domestic authorities of Poplar Housing, which the court will see at paragraph 21 of his speech, McKellen, which the court will see at paragraph 22 of the speech, and Sheffield City Council and Smart at paragraph 23, Lord Bingham said this, paragraph 997b, this reasoning, like that of Lady Justice Arden in the present case, reflects the tenor of the Strasbourg jurisprudence, and in my opinion gives effect to the purpose of the Convention. I agree with it. That's the reasoning of Lord Justice Laws in Smart. In South Bucks District Council and Porter, I wish to leave open the question whether any action by a public authority seeking possession of residential property occupied by a defendant engages the operation of Article 8. Now the question has been fully explored, I am satisfied that such actions will ordinarily do so if the residential property is occupied by the defendant as his home. But nothing I have said in this opinion should be understood as applying to any landlord or owner which is not a public authority.
Is that a safe proposition today?
Well, Lord, let me make my own position clear on this. We do not, before this court, rely on any freestanding obligation of the court to act as a public authority compatibly with Convention rights under Section 6.
Well, you don't in this case, but is it possible that in a private contractual arrangement between a private landlord and a private tenant, of course, a court would have to operate Section 6.1?
That involves, the submission I want to make in answer to that is, no, it's not possible. That issue is the issue that raises the possibility of horizontal direct effect. We'll see in a moment in one of the Strasbourg cases, which did concern an early case considered by Lord Bingham in that line of case I've just taken your lordship and my lady too, that the Strasbourg court, at least the commission, treated the position as between two private individuals, landlord and tenant, is only engaging the positive duty of the state to create a forum in which the dispute could be carried out. In other words, the court itself didn't have a freestanding obligation to respect Article 8 rights. And as the landlord in that case was not a public authority, you were limited, the court's obligations were limited to providing a court in which the dispute could be carried out. That's the way in which Strasbourg saw it in that case. It's perfectly sufficient for my purposes to say that's the correct way of looking at it. Because I wasn't personally involved in any of this trio of cases, I'm not quite sure how the argument was put, but I certainly disavow any reliance on a Section 6 obligation placed directly on the court, as opposed to the court's role in policing the activities of a public authority in taking the possession proceedings.
I mean, in a private landlord case, there could never be a Section 7(1)(b) invoking of a convention right.
Exactly. The analysis I put forward at the beginning of my submissions just doesn't work in those terms in relation to a private landlord and private landlord. Doesn't matter what the status of the tenant is. So, and as I understand it, it's that analysis which is Lord Bingham's analysis, because he does rely, either, I've forgotten whether it's in Kazi or in K, but he certainly does in one or other of the speeches on the role of Section 7. So I don't have any duty to foreclose the possibility of horizontal direct effect in some completely other circumstances.
Presumably, I mean, without raising too many hairs, but presumably in a private landlord context, it might be suggested that insofar as the legislation entitles private landlords to recover possession in certain circumstances if they've entered into the right sort of tenancy, regardless of the grounds on which they wish to recover possession, that Parliament in legislating had infringed Article 8. That would lead to a declaration of incompatibility, if it were.
That would lead to one of two possible outcomes. One is that the court would have a job of construing the legislation, potentially conformably with convention rights applying the Section 3 duty. If it couldn't do that, then the result would be a declaration of incompatibility. What it doesn't have, what's missing from that equation, as Lord Brown says, is a Section 7 defence to the proceedings.
But I think it is Mr. Arden's sword of Damocles, which would no doubt shock a lot of private landlords that he is raising. I think that is the point.
Yes, and we'll come to it in a moment. I mean, it was a concern shared by the majority in Kazi, as I understand it, that it was not possible to say with confidence, as Lord Hope has just put to me, that the analysis doesn't apply to a purely private landlord. That's why I'm quite keen to make claim what my stance is in relation to that. So going back to paragraph 24, for these reasons and those given by Lord Steyn, I would uphold the decision of the Court of Appeal and affirm its order that the issue of justification raised under Article 8.2 be remitted to the County Court. Mr. Arden submitted that this outcome would impose a large burden of expense and delay on housing authorities. I do not accept this. The Court has made it very plain, most recently of Runa Begum, that the administration of public housing under the various statutory schemes is entrusted to local housing authorities, not for this court, not for the court, to second-guess allocation decisions. Strasbourg authorities have adopted a very pragmatic and realistic approach to the issue of justification. Council will agree that even if the argument for Mr. Kazi were accepted, the occasions on which a court will be justified in declining to make a possession order will be very highly exceptional. This is so. Not proper to comment on the present case, since I share the Court of Appeal's view that the issue of justification should be considered by the County Court. If, contrary to the ruling of the majority of the House, effect were to be given to my opinion, I am confident that housing authorities acting in good faith in implementation of the schemes prescribed by statute would apprehend no significant increase in their litigious burden. And all of that we adopt.
Yes, I wonder, as we go through these cases, whether we're not going to find more and more, both domestic courts and Strasbourg saying, of course, it's highly exceptional. Yes. And all the time one wonders whether it really is.
Well,
I think we saw in one of the later cases that the notion of the housing authority getting the wife to bring the tenancy to an end seems to have been standard practice in Birmingham City Council for a long, long time. It can't be that exceptional, can it?
No, well, certainly the McCann situation, which is what your lordship is describing, was not exceptional.
No. Is there any discussion in Kazi, which is more or less the McCann situation,
Yes.
of how one would approach proportionality? I mean, here you are, you've got a joint tenancy, husband and wife, one of them goes, still the home of the remaining one. How do you go about saying, well, what's the legitimate aim in getting rid of the remaining one?
Well,
how proportionate is it?
The vice in McCann, we're jumping ahead slightly, but I should own up to the fact that I formulated the domestic proceedings and indeed the petition in McCann. The vice in McCann was that there was an express ground for seeking possession in domestic violence cases, which depended upon the court considering it reasonable to make an order. The effect of the proceeding of the procedure which Birmingham adopted simply circumvented.
Yes, I understand that, which is why I was asking
the
whether in any of these joint tenancy cases, domestic cases, there's any discussion of how you would approach proportionality in that situation. Forget the domestic violence aspect of it. You've simply got a separated couple.
Yes, you've got a separated couple, and presumably you would look at the arguments that the housing authority put forward as to the need to make the accommodation available for others. What gets completely missed in both Kazi itself and in McCann is any evaluation of that aspect of the case.
So it's a full proportionality review of the arguments on both sides. On the one hand, you consider all the arguments put forward by the housing authority as to its need for housing stock on the particular facts. And on the other hand, you consider all the aspects of the matter from the point of view of the tenant, and including the fact that there's only one of them left and so on.
I'm willing to contemplate that position in these joint tenancy cases for this very important reason, which is that the husband in both Kazi and McCann will have been long-standing, perfectly lawful occupiers of the premises who are dispossessed or in danger of being dispossessed purely because of the interrelationship between the statutory scheme and the common law power in the wife to serve a notice to quit. I do not accept that that means that in other situations, even where you've got long-standing occupiers, the same considerations will apply. We'll come in due course to the facts of K, where in K, as opposed to Price, the occupiers were long-standing occupiers. They'd been let into possession in short-term tenancies, short-term licenses, which were ultimately held to be secure tenants. Landlord, who is a public authority, then terminates the head lease, and Lord Bingham and everyone in K holds there's nothing to remit to the county court. And I accept that. Even long-standing occupation is not enough necessarily to get a proportionality argument off the ground. A very important factor on the facts of K was that alternative accommodation was being made available. The proportionality argument was it's disproportionate to remove me from this house, even though you're making house 2 available to me. I fully accept that that's won't get off the ground on the authority of K. It may be that S, which we'll come to in a moment, which is another case of a long-standing occupation, is another example where the proportionality argument won't get off the ground, although there are particular social factors to be borne in mind in relation to S. But the joint tenancies do have the feature that the husband, if it is the husband who's being removed, has a long-standing and contractual right to occupy.
While we're contemplating the phrase very exceptional,
yes.
And you may not be in a position to deal with this, I think it would be helpful at some stage to have some sort of indication of the volume of cases that are caught under the demoted tenancy scheme.
Yes,
I don't imagine you're in a position to do that, but perhaps Mr. Arden or the Secretary of State can give us some sort of feel for it. And there are two points, of course, those that are brought in under the scheme in the first place, and those in which possession orders are actually granted at the end of the period.
I hope the Secretary of State can... You'll also ask a specific question in relation to demoted tenancies rather than more generally.
Yes, it just gets
volume
this
impact
particular
of Lord
case.
Bingham's analysis.
Yes, I mean, obviously it's a huge field otherwise, but this is a very particular point on demoted.
Well, yes. I can't give an answer immediately, but I'm sure those of us behind the bar can find some way of answering that. Can I just say, I mean, it may be helpful, as we've got on to exceptionality, can I just say a word about how I urge the court to approach it, which is, despite the fact that in Lord Bingham's speech, there's a reference to how exceptional cases will be in which an Article 8 defence arises, and the same approach is repeated in K. In our submission, it will be a mistake to pose a legal test of exceptionality. That can't be the answer.
Why does that come as no surprise to us?
Hoang all over again.
Sensible man.
And Norris.
In our submission, it's very similar. We ought to arrive at a very similar position to that which we arrived at in the immigration cases, such as Huang. The test isn't exceptionality. Instead, one looks at the sort of factors that have led the Strasbourg court to hold that removal is not justified. When that is done, it will be seen as a matter of fact that it will be, in an exceptional case, that the ordinary incident of immigration control does not lead to removal.
Well, that is actually why I asked how one would go about approaching proportionality in the joint tenancy cases, because the joint tenancy cases are very numerous.
They're very numerous, but they have a very particular ingredient, which is the one I tried to identify.
They have a very particular ingredient, and it's a very important ingredient.
Yes.
And speaking entirely for myself, I would be quite surprised if the outcome of a proportionality exercise in the joint tenancy cases led only very rarely, exceptionally, to saying that the possession order should not be granted.
Yeah, I'm not making any contrary submission.
No, I thought you wouldn't. Yes.
At all. What I do say is that the sensible way forward for the court, in my respectful submission, is to adopt the approach that Lord Bingham and I think Lord Walker took in this series of cases, which is not to attempt to define exceptionality. I will go further and say it simply wasn't the test. But it is possible to define the background factors which will make it which will be highly relevant to the exercise of the proportionality test. An uncontradicted property right in the part of the local authority is plainly a very major consideration in the proportionality balance. Provision of alternative accommodation is another. And it's only where there is something that suggests a long-standing relationship between the tenant and the public authority that one is only going to begin to get a different answer.
Are you prepared to accept the point that I think Mr. Arden makes, that somebody who's representing the tenant who's been dispossessed will try to take the point if possible, and therefore, while it may be the number of cases in which the defence succeeds are very exceptional, it wouldn't be right to imagine that it's very exceptional that the point is taken.
Well, the answer to that is that the court will evolve a series an answer to these questions which doesn't depend upon applying an exceptionality test, but which does identify the factors that are highly relevant, namely the very considerable weight to be placed on the property right of the landlord, if that is straightforwardly made out, so that the case law will bed down to give the answer over time. I mean, there will be a period of the case law developing. But that's precisely what's happened post-Huang in the immigration field. And in my submission is the right answer here.
When you're dealing with demotion, you're into a different ballgame. You're not into a situation where you've got a prima facie right to terminate, providing it's reasonable or proportionate. Here, proportionality or balance or discretion is the only exercise.
That I agree with. I mean, there is a sense in which this scheme does not raise directly the issues that were raised by the joint tenancy cases and so on, where there's an uncontradicted and uncontradictable domestic property law right. I mean, here, if one says simpler from my point of view, you have a public authority that has to decide whether or not to end the demoted tenancy. I've never really understood why it is that public authority shouldn't have to act proportionately. Bearing in mind all your lordships, the observations your lordship was making earlier, that you come there against a background where there's already been a demotion order, and therefore the tenant is on probation, if that's the right way of looking at it. But the proposition that in our scheme, the public authority doesn't have to obey Section 6.1 in our submission is an odd proposition. My Lord, can I then, before going on to the other speeches, just take your lordships very shortly to the cases that are identified by Lord Bingham in paragraph 14 onwards. And they will be in either volume 12 or volume 13 of the authority. De Palma is at volume 12, tab 108. If your lordship looks at page 149 of the first page of the report, your lordships my lady will see that this is a case where the applicant occupied a flat under a long lease, pursuant to which she was liable to pay by way of additional rent a service charge representing her proportionate share of the expenses incurred by the landlord in the insurance, repair and maintenance and renovation of the building. Then there were a series of disputes, detail of which I won't take the court's time in reading, but the upshot of it was that the applicant made an application to the county court to avoid the forfeiture of the lease. County court didn't.
This was a private landlord.
Absolutely.
Is it going to help us at all?
Well, only in relation to the concern that your lordship raised with me, or Lord Hope raised with me, about how secure one could be that our analysis does not apply in the private landlord position. Actually, where we are. I don't think it's taken much further. Look, the
Really,
article
155.2, isn't it?
1552 is dealing especially with Article 8.
That's just to deal with my Lord Hope's point about private landlords.
Yes.
And it's quoted by, most of it's quoted by Lord Bingham in Carsey, I think.
It is.
Yeah.
Yes.
Yep.
That's the domestic right to possession trumps all, isn't it?
It's a domestic right to possession, but I'm misremembering it, but I thought there was... Yes, the bit that actually goes more directly to Lord Hope's concern is at the foot of page 154. I'm sorry to be slow in identifying this. The foot of page 154, just before the passage dealing with Article 8. Where the court is still dealing with Article 1, Protocol 1. And the very foot of page 154, the Commission say it's true that the landlord issued proceedings in the domestic courts in order to forfeit the applicant's lease. This fact alone is not, however, sufficient to engage state responsibility in respect of the applicant's rights to property, since the public authority in the shape of a county court merely provided a forum for the determination of the civil right in dispute between the parties, contending that the state responsibility for the interference with rights protected by the Convention arises in connection with this complaint. The applicant seeks to demand that the state be subject to a positive obligation to protect the property rights of the individual in the context of his dispute with another private individual, and so on. So that there the state, the complaint fails because it's essentially an allegation of that the court has a duty to positively protect the rights of the individual, of the two individuals. Well, Lord, the next case is P. Your Lordship's note, I won't take your Lordship's to P, but P is a case which was an occupation of a caravan site for many years, the eviction being carried out by a public authority. P is to be found at volume 13, tab 114. If the court, at its leisure, goes back to P, it is in fact apparent that since P is cited by Lord Bingham, we have the decision of the Strasbourg Court in Connors, which takes a rather different line to P and produces a different result. So we've moved on one from that. Then we have Ure, which is another joint tenancy case.
I wasn't quite sure I picked that point up, Mr. Rebel. Are you saying we shouldn't bother with P? No.
You say P is overtaken by Connors.
I'm saying P's overtaken by Connors. Probably trying to take things too quickly. If your Lordship goes to volume 13...
I don't want to take up time, but we can forget about P because of Connors, can we?
Yes. I mean,
it might be better not to get us to have it out and open it up. You then say it's of no importance.
Right. Yeah, I've got the message.
I mean, do we need as much archaeology as this anyway? I mean...
Well, I'm just thinking precisely that. I think the answer may be no, if your Lordships don't want it. Can I just give you, Lordships, the references without going to them, I mean, if that's where we're going? If you don't want them, even that. The summary of them all is in Lord Bingham at paragraph 20. Where he says, it seems to me that these authorities, although inconclusive, give somewhat more help to Mr. Carsey than to the Council. They reveal a tendency to assume an interference or lack of respect and then to consider justification, an issue decided against the applicant in all the cases except Larkas, where the complaint was of discrimination in conjunction with Article 8. It is noteworthy that although in all 5 cases held to be manifestly ill-founded, the applicant had under domestic law no arguable legal right to remain in the property from which he or she had been evicted. The adverse decision was never based on that short, and if correct, obvious, ground. Well, taking then as read that line of Strasbourg authority, we have the opinion of Lord Steyne, who agrees with Lord Bingham. And your Lordships will see in paragraphs 28 to 30
sorry, what is this?
This is Lord Spain in passing.
Okay.
Where he identifies the questions in the same way as Lord Bingham does, and says that on the second question, which is the question whether or not what the court did or proposed to do infringed his right to respect for a home, says paragraph 30, on the second question, the House is divided. While I accept that according to English concepts of stare decisis, there is in the European jurisprudence no decision directly in point, the thrust of the approach in Larkos and Mazzari supports the view that when proceedings to recover possession of the defendant's home were issued and possession was ordered, there was an interference with Mr. Carley's respect for the home. It's sufficient to say the application of no arguable legal right to remain in property, Article 8.1 is not engaged, such an obvious ground that it has inevitably been found in the part of the European exposition of reasoning. And then, like Lord Bingham, he sets out a passage from Lord Justice Laws in Smart, Sheffield and Smart, and says at the end of that passage, at page 999, letter D, paragraph 33, in agreement with the reasoning of Lady Justice Arden, I will make the order proposed by Lord Bingham of Cornhill.
It's interesting that in paragraph 29, he regards the first issue as the main point in the case.
Yes,
and that's certainly my recollection.
Later on in I think the speech of Lord Millett, amongst others.
Yes.
Yes.
I remember Lord Scott finding it very difficult to accept the point, but eventually he did. But it was so there was a state of some doubt as to where exactly Strasbourg was going on the second question. But the first question was the important one to get established, on which in the end everybody was agreed.
Yes, I accept that. And your Lordship will recall that Lord Millett takes a rather similar approach. He says, here's the answer to the first question. The second question is a narrow but important point, is the way I think he would put it. So then we come to your Lordship's speech in Hope. Sorry, you are Lord Hope. It may have been in Hope too.
But two others agreed with me.
Yes, indeed. Your Lordship's starting point was a consideration of the practical implications of the view being taken by the minority as to the need to remit the case. And your Lordship set out in the end of paragraph 36, the practical implications that your Lordship thought pertained from the approach of the answers to the question of whether the making of the order would be proportionate. The Lordship said at letter 1000, letter A, if to the answer to that question the court must always be given that opportunity, it will be in the discretion of the court in all cases to decide whether or not an order for possession should be made. This will only not be so not only in those cases where there are statutory safeguards that must be satisfied. The court will have a discretion to exercise even in those cases where the tenancy has come to an end by the operation of law. Where the tenancy has come to an end by the operation of law, there's an absolute right to possession. There are no statutory safeguards other than the basic rule that possession cannot be taken without an order from the court. See the protection from the Eviction Act 1977. So your Lordship is describing the result of the proportionality exercise as the exercise of a discretion by the court. Can I just submit that, with respect, I don't accept that label. It's not a question of the exercise of discretion. It's a question of the application of what will become known principles to the proportionality exercise. At this stage, we may not know what the outcome will be in each and every case, but we do know already, that in a very large number of cases where there is, to use your Lordship's words, an absolute right to possession, the proportionality argument will not produce a different answer.
I rather sort of thought my Lord was using the word in the sense of judgment, as it's very often used.
I think
And there is
that may be right, but
there's a judgment to be made.
It doesn't, in a way.
So it's a matter of discretion.
The reason I'm saying this is because the concern appears to emerge from the consultation paper, which is cited in paragraph 38 of the speech.
Yes, I mean, the word discretion, I think, was actually used in the consultation paper.
Yeah, I suspect that's right.
From there, but
And so the submission I want to make is that that's an overblown concern with respect. It was in the consultation paper and can be seen now to be. Because certainly your Lordship's citation from the consultation paper is suggesting that the authors of the consultation paper thought that there would be, quotes, a discretion to be exercised in each and every case. So that's a perspective that we are anxious to say we do not share.
In what sense is there not one to be?
Because when one looks at what goes into the proportionality pot, if I can put it like that loosely, it will be possible to identify factors which are of very considerable importance, one of which is the undoubted right of the landlord to possession, so that you are going to need something very substantial to put on the other side, which would normally arise from a long occupation of the premises under some shadow of right, before you even get to there being a real exercise, a real question of judgment for the court to operate.
The word doesn't much matter. The point is that it's an evaluative exercise which it suggested could lead to a lot of argument in a lot of cases, whatever you say.
Yes, and the question then is, well, how real is the prospect that you're going to have a lot of argument in a lot of cases, given the fact that you can spell out the ingredients that are necessary in a proportionality exercise anyway?
You've got to get some ground rules laid down.
Yes.
Such as personal circumstances don't weigh very much compared to an absolute legal right.
Yes. Absolutely. That is very much the perspective I'm urging on the court. And it's like, I repeat, the analogy with Huang, when we got to the stage of the Court of Appeal in Huang, where the Court of Appeal had formulated an exceptionality test. The framework of the immigration rules will normally provide the answer, but it's a wholly exceptional case that will lead to a different result, which had led to immigration judges running up and down the country trying to decide whether or not the case in front of them was indeed truly exceptional. Now, in our submission, we shouldn't be repeating that exercise when it comes to Article 8 in possession proceedings, instead of which one should, as a matter of, have a principled evolution of the factors that are relevant, which will provide an answer over time to the question. Well, then going on through my Lord Hope's speech, paragraph 50, having considered the origins of Article 8 and the interest it was there to protect, the Lordship said in paragraph 50, it seems to me that the following conclusions can be drawn from the language of Article 8.1 in the light of the observations in Marx. The right to respect referred to in this paragraph refers to the person's home, but the essence of this right lies in the concept of respect for the home as one among various things that affect a person's right to privacy. The context in which the reference to the person's home must be understood is indicated by the references in the same paragraph to the private and family life and to his correspondence. The emphasis on the person's home as a place where he is entitled to be free from arbitrary interference by public authorities. Article 8.1 does not concern itself with a person's right to the peaceful enjoyment of his home as a possession or as a property right. Rights of that kind are protected by Article 1 of the First Protocol. So, and your Lordship built on that to come to the conclusions which your Lordship did in paragraph 82. I'll come back to the intervening parts in a moment, but your Lordship's conclusion at the end of the speech in paragraph 82, was I've been to read 81 too. In the second paragraph of his speech, which I had Lord Steyn says that the approach of the majority empties Article 8.1 of any or virtually any meaningful content, and it allows domestic notions of title, legal and equitable rights to colour its interpretation. I hope that I've been able to show that this is not so. I believe that the key to a proper understanding of the issues in this case lies in an appreciation of the fact that Article 8 regards a person's home as an aspect of his right to privacy. The interpretation which I will give to the concept of a person's home in this context is broad enough to give a full measure of protection in a wide range of circumstances that may be engaged where a person's right to respect for his home is interfered with by the public authorities. The issue which arises in this case is, by way of contrast, a very narrow one, which has more to do with the law relating to property than respect for a person's privacy. I do not say that the right to respect for the home is irrelevant, but I consider that such interference with it as flows from the application of the law, which enables the public authority landlord to exercise its unqualified right to recover possession following service of a notice to quit which has terminated the tenancy, with a view to making the premises available for letting to others on the housing list, does not violate the essence of the right to respect for the home under Article 8.1. As a conclusion which can now be applied now to all cases of this type generally. So we do respectfully submit that approach to that part of Article 8, which deals with the right to respect for the home, which sees it simply as part of the right to respect for private life, is a mistake, and clearly can be seen to be a mistake in the subsequent cases such as McCann and indeed Connors.
I think it's fair to point out that I did draw a lot of this from Marx, which I quote at paragraph 46,
Indeed.
which maybe it's been overtaken by later authority, but it certainly did make the point that the essence of Article 8 was to protect the individual against arbitrary interference. And the point is, if you have a structure such as we were contemplating there, you couldn't really say it was arbitrary.
I completely accept that, and there's not a complaint about the reasoning as it stood at the time of Kazi. What I do say is that an approach to Article 8, which is mediated solely through Marx, cannot live with the subsequent Strasbourg cases such as Connors and McCann. That's the point of this, really.
Yes.
Am I right in thinking that Strasbourg found Kazi inadmissible?
Yes, you are right in thinking that.
It's one of the things I seem to remember being told.
Exactly.
And a nice little table that Mr. Arden provided us with in K.
Yes. I mean,
But not on this point. I mean, isn't that right?
Clearly they did, yes.
I mean, they may have felt, one suspects, that however much you weighed proportionality, the result would be the same in that case.
I mean, there is an awkward trio of simply Strasbourg cases, because if your Lordship looks at Lord Hope's speech on page 1012, paragraph 75, there's a reference to Ure and the United Kingdom, which was another joint tenancy case. And it had been argued on behalf of Mr. Ure, both in the domestic courts and in Strasbourg, that there was something improper in the local authority seeking to persuade Mrs. Ure to serve the notice to quit. That was rejected by the domestic courts and by Strasbourg. And your Lordship will see the citation from the Commission in just below letter D, paragraph 1012, letter D. It does not appear that the manner in which the authorities balance the various interests involved, such as the interests of the leaving co-tenant, those in need of accommodation, the applicant was arbitrary or unreasonable. Thus, the applicant's housing need apparently changes, not living with his wife and child anymore, and then importantly, possibly, moreover, replacement housing accommodation had been obtained for the applicant. So one has a trio of cases. You have Ure, followed by Kazi declaring the complaint inadmissible, and then in McCann, the court does take the step of finding that there is a breach of Article 8.
Does what?
Does take the step of finding there was a breach of Article 8.
And we can't only attribute that to your intervention, Mr. Drabble, can we?
No.
There are other distinctions between the cases,
There are other
which you're going to
distinctions.
take us to.
Well, no, I put it as an evolution, and it's that for whatever reason, in McCann, the court did face up to the underlying problem, which was that if you have a joint tenancy, and you, the public authority, solicit the service of the notice by the wife, you circumvent various procedural safeguards. It's the combination of unobjectionable domestic property law and the statutory scheme which produced the problem in McCann.
Yes, it's quite interesting because that was a domestic violence case, wasn't it?
Yes.
Where there was a distinct procedure. So when Strasbourg was confronted, as in Connors, a comparison between the different routes that you have to take to get somebody out, they find it quite hard to justify taking the easier route when there is a more difficult one that probably ought to be taken. Is that a fair comment on those cases?
Well, my submission, probably no, for this reason. For this reason, that the analogy with Connors is highly material. In Connors, the statutory scheme, well, there wasn't a statutory scheme providing any protection for Mr. Connors. That was the whole point.
But there were for other people similarly situated.
People, hence the possibility. There was obviously, as your ladyship knows, an Article 14 argument. In McCann, the statutory scheme applies to the position of Mr. McCann. It's there was a different remedy that could have been taken against Mr. McCann personally. Now, if you go then to, instead of to McCann, you go to Ure, the position is that there is, to Kazi probably more relevantly, there is no statutory basis on which possession could have been obtained against Mr. Kazi, but Strasbourg could have held, and then my submission after McCann would hold, that the eviction of Mr. Kazi simply because, I say simply because of the service of the notice to quit, viewed as a matter of common law by Mrs. Kazi, had the effect of meaning that Mr. Kazi had no procedural protection.
But on the facts in Kazi, there had been the feature that he'd actually applied then for a sole tenancy and been refused on grounds relating to the size of the accommodation, that he wasn't entitled to family-sized accommodation, which one suspects might have been an important influence on the Strasbourg court when looking at the prospects of proportionality being any help.
Well, I don't dissent from that. I mean, yeah. Well, I don't think I need read at this stage any more of Lord Hope's speech on the basis that the conclusion that was come to at the end of paragraph 82 and 83, which is that Article 8.2 never provides a defence to possession proceedings where there is an absolute and uncontradicted private law right to possession, has clearly been overtaken by the case law to which I will now come. Accordingly, one can look at the case law from that perspective.
You don't challenge what Paul Hope talks about, the key to proper understanding, the fact that Article 8 regards a person's home as an aspect of his right to, let's say, private life and so on. You don't challenge that, do you?
Yes, I do. They're obviously closely interconnected, but I do say that it's apparent from the later case law that there is that the right to respect for a home is not simply part of a right to respect for private life. There are different concepts under the first limbs of Article 8.1, under Article 8.1.
It's just different, yeah.
Is it
closely connected?
Yes.
It's very close to me, they seem very close. That's why I wonder how exactly the distinction works. I mean, I can see you say, of course, that you shouldn't, Lord Hope puts too much emphasis on the property, you say, rather than this. But I mean, I just can't quite see why it isn't to do with his life, his private life, his way, that's his family and all that sort of thing.
Well, I mean, that connection...
You don't say that, do you? You say, of course, there's a privacy aspect to this, but there's more to it.
Yes.
It's not just the Entiker-Carrington type aspect of Article 8. I think that's what you're saying, isn't it?
That's it's not just people breaking into the home.
No. It's a right to respect for your base, if I can put it like that.
The last sentence, of course, is very tied up with what I go on to say about the significance of the contractual arrangements and so on. I mean, throughout various passages, please don't go back over. I'm picking up the point that where you find that there is a clear right to possession given by the statute or by contractual arrangements, then that can be enforced. And so the distinction in the law, as it seemed to me to stand at the time, was an important one to make. I think now, in view of the way Strasbourg has gone, what one finds in paragraph 82 rather dissolves as a point worth contemplating, really.
Yes.
I wouldn't stand by that distinction now, in view of the fact that the point
your
I
logic
make...
has said so in the subsequent cases. So,
yes.
Yeah. But, I mean, I do say that the starting place in Kazi can now be seen to be mistaken. I mean, the starting place, which is paragraph 82 and 83, or to have been overtaken by events. It matters not which, but certainly not now to be relied on. But what has happened subsequently is a series of adjustments of the Kazi starting point to produce a result which defeats my very simple analysis, which is the one that I put forward at the very beginning of these submissions, and that one shouldn't have got there. And the last point I make on Kazi is that it does seem that at the time of the proceedings in Kazi, it would have been the view of the majority, and certainly the view of Lord Millett in a paragraph I'll now come to, that in judicial review proceedings, a disproportionality defence could have been taken. The problem in Lord Millett's eyes was that there had been no judicial review proceeding. If your Lordship, my lady, will go to paragraph 91. Lord Millett says, Mr. Kazi did not vacate the house and the council brought possession proceedings against him in the county court. The council is a public authority, and Mr. Kazi could, if so minded, have challenged his decisions to refuse his application for a new tenancy and to bring proceedings to recover possession on the grounds that they were arbitrary, that is to say, not objectively justifiable, but unreasonable or disproportionate. Such proceedings would have had to be brought in the High Court, but the county court could have been asked to stay the possession proceedings in order to permit them to be brought, though he would have had to show that they would have at least some prospect of success. Mr. Kazi did not take this course. Instead, he resisted the possession proceedings on the ground that by bringing them, the council was interfering with the right of enjoyment and respect for his home, contrary to Article 8. So at the point of departure in Kazi, the position seems to have been, or certainly in Lord Millett's view, was that proportionality would be in play in judicial review proceedings because the housing authority is a public authority. See the second sentence of paragraph 91. And so the problem that Lord Millett was confronting was, in his mind, an issue of whether or not that challenge could be brought in the county court, or could be taken in the county court.
Mr. Drabble. Shall we adjourn?
Indeed.